Hello and welcome to the 2TG Employment Monthly. My name is Lauren Hitchman and I'm delighted to bring you the first webinar in this series. Each month, 2TG will bring you a 15-minute webinar in which we take you on a whistle-stop tour of some of the key developments in employment law over the past month. I will be discussing 3 cases today, which cover 2 of employment law's hottest topics, COVID and Cabbies. The first 2 cases, X and Y and Allette and Scarsdale Grange nursing home, highlight the far-reaching impact of COVID-19 on employment disputes. The third, Johnson and Transopco UK, discusses the worker status of a black cab driver. So turning to the first case, X and Y, the claimant in this case brought a claim of unlawful discrimination in which the protected characteristic was religion or belief. The claimant stated that her belief was a fear of catching COVID and a need to protect herself and others. At a preliminary hearing, the judge considered whether this belief fell within Section 10 of the Equality Act 2010. Section 10 provides that a belief means any religious or philosophical belief, and a reference to belief includes a reference to a lack of belief. The tribunal was referred to the case of Grange plc and Nicholson, in which the EAT set out the 5 criteria that must be satisfied for a belief to fall under Section 10. In the interest of time, I won't go through all of the criteria, as they were either not in dispute or were not addressed at length. I will instead focus on 2. The first is criteria 2, which is that it must be a belief and not, as in McClintock, an opinion or viewpoint based on the present state of information available. The reference to McClintock is to McClintock and Department of Constitutional Affairs, in which it was held that to constitute a belief, there must be a religious or philosophical viewpoint in which one actually believes. It is not enough to have an opinion based on some real or perceived logic, based on information or lack of information available. As to this criterion, the tribunal held that the claimant's fear did not amount to a belief. It was a reaction to a threat of physical harm. It was also a widely held opinion based on the present state of information available. The third criterion that the tribunal discussed was that it must be a belief as to a weighty and substantial aspect of human life and behaviour. The tribunal considered that whilst the belief was a weighty and substantial one, it was about the claimant herself and the protection of herself and her own steps to protect others. She did not rely on a wider belief than this, and as a result, the criteria was not satisfied. The tribunal therefore found that the claimant's belief did not meet the 5 Nicholson criteria and was not a philosophical belief within Section 10 of the Equality Act. Now, of course, it remains to be seen how this logic will be applied to other beliefs relating to COVID, such as, for example, a belief in vaccine efficacy. Turning to our next case of Allette and Scarsdale Grange Nursing Homes Limited. The claimant was a care home worker and the respondent was a small family-run care home business. The claimant brought a claim for unfair dismissal and wrongful dismissal. In December 2020, the government had announced the rollout of the COVID vaccination programme to nursing homes, residents and healthcare workers. There was a dispute as to the claimant's reason for not taking up this vaccine. At the hearing, the claimant claimed that she did not want to have the vaccine for various reasons. Firstly, due to its safety. Secondly, because she was a practicing Rastafarian and it was against her beliefs to take any form of non-natural medication. And thirdly, she had already had COVID and believed that she would have immunity. The employer's position was that the claimant had made no mention of her religion or her reservations about pharmaceutical medicines when explaining her reasons for not wanting to take the vaccine. The employer therefore summarily dismissed the claimant for gross misconduct on the grounds that she had failed to follow a reasonable management instruction. Ultimately, the tribunal found that the employer genuinely did not believe that the claimant had a reasonable excuse for refusing the vaccine. She had not mentioned her religion when she had first been asked about the matter. The tribunal found in all the circumstances, and in particular, the state of the pandemic at the relevant time, the tragic consequences of a recent outbreak of COVID at the home, and public health advice, the decision to make the vaccination mandatory for staff providing close personal care to vulnerable residents was a reasonable management instruction. The tribunal found that, quote, in the specific circumstances of this case, therefore, I find that the claimant's actions amounted to gross misconduct. That does not mean that a refusal to be vaccinated would amount to gross misconduct or even misconduct at all in another case on different facts. As to the law, the tribunal considered Article 8 of the European Convention on Human Rights, namely the right to respect for private and family life. In doing so, the tribunal considered X and Y, in which Lord Justice Mummery held that if the dismissal of the applicant was in circumstances falling within Article 8 and was an interference with the right to respect for private life, it might be necessary for the employment tribunal then to consider whether there was a justification under Article 8, subsection 2, for the particular interference. The tribunal found that the claimant's dismissal for refusing to have the vaccine did indeed fall within the ambit of Article 8. It therefore went on to consider whether there was justification for this interference. It considered that the respondent had a legitimate aim for both the management instruction requiring employees to be vaccinated and the dismissal of the claimant for unreasonably refusing to comply. There were two legitimate aims. The key one was to protect the health and safety of residents, staff, and visitors to the home. The second legitimate aim was concern about the withdrawal of the respondent's insurance cover. The interference in the claimant's private life was therefore deemed to be necessary. The claimant also considered the Article 8 rights of the residents, staff, and visitors in the home, and found that in all the circumstances, for an unvaccinated person to work in the home would pose a significant and unjustified interference with those rights. The tribunal then went on to find that the interference was proportionate in the circumstances. Ultimately, and having applied the standard test for unfair dismissal, the tribunal considered that the claimant's dismissal was fair. Further, the tribunal dismissed the claimant's claim for wrongful dismissal on the basis that her refusal to be vaccinated amounted to a repudiatory breach of contract. A question arises from this case as to how the tribunal would have approached the question if the employee had worked in a different industry and not in the care home sector. Turning now to our final case today, which is Johnson and Transopco. The claimant was a black cab driver and the respondent was the operator of a mobile phone application known as My Taxi. Via the respondent's app, potential passengers could hail a taxi and nearby taxis could then either accept or reject the job. As a preliminary issue, the ET considered whether the claimant was a worker under section 230, subsection 3 of the Employment Rights Act. Now, this will be a familiar provision to those of you listening, so I won't read it out in detail, but the tribunal was looking at whether the claimant could be classified as a so-called Limb B worker. The ET found that the claimant was not a worker of the respondent. The Employment Tribunal made two key findings in this respect, which were summarised by the Employment Tribunal as follows. First, the respondent did not deal with passengers as the agent of the claimant. The passengers contracted for transportation services as principal. These were delivered pursuant to a separate contract between the claimant and the respondent. However, the claimant was not a Limb B worker of the respondent. The claimant had an obligation of personal service to the respondent, but the respondent was a client or customer of his taxi driving business. He therefore fell within the exception contained within section 230 subsection 3 as the respondent was a client or customer of the claimant's taxi driving business. The claimant appealed on the second part of the tribunal's decision. In a lengthy judgment, the EAT dismissed the appeal. I'll run through a few of the key points of this judgment, but it's one that warrants reading in full. The tribunal had been entitled to consider the proportion of time that the claimant spent using the app, the income he had earned through it, and the rate at which he declined and cancelled jobs when considering whether his work for the respondent was part of his own business. The ET's findings on this point also supported the fact that he was not in a dependent working relationship. Further, the tribunal's finding of fact in relation to the allocation of financial risks, control, and integration were neither wrong in law nor perverse. For example, despite the respondent being able to sanction the driver for failure to accept rides, this was not a significant measure of control when weighed against other factors. The respondent had to maintain its brand. The EAT made an important observation as to the fact-dependent nature of the analysis of worker status. It held that the nature of the legal test, containing as it does an element of factual subordination or dependency, means that different outcomes in different cases involving the same app cannot be ruled out. Ultimately, the EAT could see no basis on which it could interfere with the tribunal's conclusions, and thus the appeal was dismissed. So, as the EAT observed, the case shows how fact-specific an analysis of worker status will be, even on apps that share a similar premise. For example, an entirely different conclusion was reached here than in the well-known Supreme Court case of Uber and Aslan. That brings us to the end of today's webinar. If you have any questions about any of these cases, please feel free to send me an email. Do look out for the next episode of the 2TG Employment Monthly, and thank you very much for tuning in today.